Licensing, privilege or right? Since 1915, when California first began to issue licenses, driving has been held to be a privilege granted and revocable by the state. DMV has been granted the authority to deal with these procedures by the legislature. Requirements for licensing. Stated briefly, it is unlawful to drive on any public roads or property unless licensed, and the license must be correct for the class of vehicle driven. Certain exemptions apply. You must apply upon entry into California as a resident. You have 10 days to submit a change of address. You must now provide your Social Security number when applying for or renewing a license or registration.
You are required to have a valid and current driver's license, vehicle registration, and insurance in order to operate a vehicle. All of these items must be valid and current at the time that you operate your vehicle. Even if your vehicle meets all the requirements to drive safely on the road, if any of these are expired or invalid in any way, then you cannot and should not drive. In addition to keeping these items up to date, you must also maintain proof of their validation in the vehicle when operating it. If you are pulled over by an officer while not having one or all three, then you can expect to be fined for it. It's best not to drive until you can ensure that you have valid and current proof of all these items.
Note, under the Safe Streets Act of 1994, any driver who is unlicensed or has had their privilege suspended or revoked may have their vehicle impounded and sold. If a license is suspended or revoked, it must be returned to DMV within 15 days of the effective date. A fee will be charged if it is not returned. Classes. The following are the types of licenses available in California. A. Any vehicle. Motorcycle must have an M endorsement. B. Bus, farm labor vehicle, single vehicles with 3 or more axles. C. You may drive a 2-axle vehicle with a gross vehicle weight rating, GVWR, of 26,000 pounds or less. 3-axle vehicle weighing 6,000 pounds or less, gross. House car, 40 feet or less. 3-wheel motorcycle. Van pool vehicle designed to carry more than 10 persons, but no more than 15 persons, including the driver. Note, the driver must have a valid medical certification on file with DMV and carry a valid medical card. The driver must keep in the van pool vehicle a statement signed under penalty of perjury that he or she has not been convicted of reckless driving, drunk driving, or hit and run in the last 5 years. You may tow a single vehicle with a GVWR of 10,000 pounds or less, including a tow dolly, if used. Trailer coach or fifth-wheel travel trailer under 10,000 pounds GVWR when towing is not for compensation. Fifth-wheel travel trailer exceeding 10,000 pounds but under 15,000 pounds GVWR when towing is not for compensation and with endorsement. A farmer or employee of a farmer may drive any combination of vehicles with a GVWR of 26,000 pounds or less if used exclusively in agriculture operations and it is not for hire or compensation. Note, Class C licenses may not tow more than 1 vehicle. A passenger vehicle, regardless of weight, may not tow more than 1 vehicle. No motor vehicle under 4,000 pounds weight may tow any vehicle weighing 6,000 pounds or more gross. M. 2-wheeled motorcycle only. M. 2-wheeled motorcycles only. License refusal and restriction. Remember, driving is a privilege, not a right. It is important to be aware of reasons why you would get your license restricted. 1. A person with a history of alcohol and/or drug abuse can be refused a license. A person with a substance abuse problem is a hazard to himself and others. He or she should not be permitted to drive a motor vehicle. If the DMV becomes aware of such a problem, it will legally refuse to issue a driver's license. 2. Any person who has used his or her license illegally could have it revoked and be denied another license. 3. Lying on a driver's license application is grounds for refusal to issue a license. 4. Failure to demonstrate a minimal level of driving skill is grounds for refusal. 5. The DMV has a legal right to refuse to grant a license to people whose medical condition makes them a driving hazard. Provisional licenses for minors. A driver's license issued to a person at least 16 years of age, but under 18 years of age, shall be issued pursuant to the provisional licensing program. During the first 12 months after issuance of a provisional license, the licensee may not do any of the following unless accompanied and supervised by a licensed driver who is the licensee's parent or guardian, a licensed driver who is 25 years of age or older, or a licensed or certified driving instructor. A. Drive between the hours of 11 p.m. and 5 a.m. B. Transport passengers who are under 20 years of age. 2. A licensee may drive between the hours of 11 p.m. and 5 a.m. or transport an immediate family member without being accompanied and supervised by a licensed driver who is the licensee's parent or guardian, a licensed driver who is 25 years of age or older, or a licensed or certified driving instructor in the following circumstances. A. Medical necessity of the licensee when reasonable transportation facilities are inadequate and operation of a vehicle by a minor is necessary. The licensee shall keep in his or her possession a signed statement from a physician familiar with the condition, containing a diagnosis and a probable date when sufficient recovery will have been made to terminate the necessity. B. Schooling or school-authorized activities of the licensee when reasonable transportation facilities are inadequate and operation of a vehicle by a minor is necessary. The licensee shall keep in his or her possession a signed statement from the school principal, dean, or school staff member designated by the principal or dean containing a probable date that the schooling or school-authorized activity will have been completed. C. Employment necessity of the licensee when reasonable transportation facilities are inadequate and operation of a vehicle by a minor is necessary. The licensee shall keep in his or her possession a signed statement from the employer, verifying employment and containing a probable date that the employment will have been completed. D. Necessity of the licensee or the licensee's immediate family member when reasonable transportation facilities are inadequate and operation of a vehicle by a minor is necessary to transport the licensee or the licensee's immediate family member. The licensee shall keep in his or her possession a signed statement from a parent or legal guardian, verifying the reason and containing a probable date that the necessity will have ceased. Violation of license restriction. At any time, the DMV has the right to restrict your license. If you fail to comply with your driving restriction, several penalties may be placed on you. Your vehicle may be impounded and subjected to storage fees, or worse, sold. You may be fined. You may even go to jail. You may be penalized with one or all of the above penalties. Licensing control measures. Traffic violations can damage your driving record. The DMV has a point system to gauge the quality of your driving, and the more points you accumulate, the more negligent you are considered to be. Both the DMV and your insurance company use the point system to determine penalties. Most traffic violations and minor accidents will count 1 point against a driver's license. 2 points are assigned for the following: reckless driving, vehicular manslaughter, driving over 100 miles per hour, illegal transport of explosives, causing injury or death while avoiding a law enforcement officer, driving under the influence of drugs or alcohol, hitting an unattended vehicle without notifying the owner, driving on the wrong side of a divided highway, causing property damage, injury, or death, and then fleeing the scene without reporting to traffic law enforcement authorities, speed contests, drag racing on public streets. The DMV considers drivers negligent operators of a motor vehicle and subject to license suspension or revocation if they accumulate 4 points in a 12-month period, 6 or more points in a 24-month period, 8 or more points in a 36-month period.
License penalties for negligent driving. The Department of Motor Vehicles developed a traffic control system called the Negligent Operator Treatment System, NOTS. Since 1915, when California first began to issue driver's licenses, the DMV has had some responsibility for highway safety through its licensing authority. Through the years, this obligation has been re-emphasized many times in legislative actions. The enforcement procedures given to the DMV include suspension, revocation, and cancellation of a driver's license.
The Negligent Operator Treatment System, NOTS, is based on negligent operator points and consists of a computer-generated series of warning letters and progressive sanctions against the driving privilege. NOTS affects California drivers 18 years of age and older. Younger, provisional drivers are also included in the NOTS program if they violate provisional probation or suspension. Provisional drivers are provided a hearing under Vehicle Code 12814.6, only if they are involved in a collision. Negligent operator points. NOTS actions are based on the number of negligent operator points drivers add to their driving record within specified time periods. Negligent operator points are added to the driving record upon receipt of conviction notices from courts and reports of responsible collisions from law enforcement which indicate that the driver contributed, was at fault, or was responsible to any degree or in any amount for the collision. The initial reporting of the responsibility for a collision by law enforcement can be refuted by credible evidence presented by the driver at an administrative hearing. The Department shall consider all evidence submitted in reaching a final determination with regard to the driver's negligent operator status.
Suspension. Suspension of a driver's license is an action taken by the DMV that suspends a driving privilege for a specified period of time. A driver's license still exists, but a person cannot use it to drive until the suspension has been removed. Revocation. The revocation of a license is a permanent removal of a driver's license. The driver's license will be physically taken from a person and destroyed. It may be reinstated only after the driver requests reinstatement and has satisfied the DMV that whatever events causing the revocation have been corrected. If the DMV allows the person to drive again, he or she must repeat the original process of getting a driver's license, including application, testing, and fees. Cancellation. Cancellation of a license occurs when, for any reason, a driver voluntarily elects to surrender his or her license to the DMV. Protecting one's driving record is an act of intelligence and responsibility. Much of what drivers do involves common sense and having a safe driving attitude. They must have good driving skills, plus a solid knowledge of the traffic laws of the state in which they are driving. With these things in place, any person of driving age can enjoy the privilege of driving for many years of safe transportation. Negligent driving and loss of license for drivers over 18 years of age. Your license can be taken away if you break the law or become an unsafe driver. When you are stopped by a police officer and cited for a traffic law violation, you sign a promise to appear in traffic court. There you may plead guilty or not guilty, or you may forfeit, pay bail. Paying bail is the same as a guilty plea. If you ignore the traffic ticket and don't keep your promise to appear in court, the failure to appear, FTA, goes on your driver record. If you fail to pay a fine, FTP, the court will notify DMV, and this will also show on your driver record.
If you fail to pay a fine, FTP, the court will notify DMV, and this will also show on your driver record. Even one FTA or FTP will cause the department to suspend your license. Ending the suspension will cost you a reinstatement fee of $55. Each time you are convicted of a moving traffic law violation, the court notifies the DMV. A record of this conviction is placed in your driver license file.
Suspension of license by a judge. A judge may suspend the license of anyone convicted of breaking speed laws or reckless driving for up to 30 days on the first conviction and up to 60 days on the second conviction, and up to 6 months on a third or later conviction. Suspension may result from conviction of driving under influence of liquor or drugs, hit and run, reckless driving causing bodily injury, failure to stop at a railway crossing. Regardless of point count, many serious offenses in which a vehicle is used are punishable by heavy penalties, such as fines and/or imprisonment. Felony drunk driving, grand theft, manslaughter, and DUI of narcotics or other dangerous drugs, injury or death caused while evading a peace officer.
Driver education and training. The minimum age for issuance of an instruction permit is 15 years 6 months. The department, for good cause, may issue an instruction permit to any physically and mentally qualified person who meets the following requirements and who applies to the department for an instruction permit, is age 15 years and 6 months or over, and has successfully completed an approved course in automobile driver education and is taking driver training, or is enrolled and participating in an integrated driver education program. SB 1055, DMV fee increases. Increases several fees and penalties paid to the DMV. The fees were increased to stave off a shortfall in the Motor Vehicle Account, MVA. The MVA is largely funded from constitutionally protected revenue derived from motorist fees and is used to support the California Highway Patrol and the Department of Motor Vehicles. Fee increases include commercial drivers. States that a driver of a commercial vehicle may not operate a commercial motor vehicle for 1 year for the first conviction of specified offenses, including DUI, hit and run, or vehicular manslaughter, while driving any vehicle, not just a commercial vehicle. CVC 15302 provides for permanent disqualification of a commercial driver for 2 or more convictions of specified offenses while driving any vehicle. Required declaration on an original or renewal application for a driver license. Adds Penal Code sections 241.5 and 243.65. This law provides an increased penalty for assault and battery crimes committed against highway workers engaged in the performance of his or her duties. 241.5. A. When an assault is committed against a highway worker engaged in the performance of his or her duties, and the person committing the offense knows or reasonably should know that the victim is a highway worker engaged in the performance of his or her duties, the offense shall be punishable by a fine not to exceed $2,000, or by imprisonment in a county jail up to 1 year, or by both that fine and imprisonment. B. As used in this section, highway worker means an employee or contractor of the Department of Transportation who does one or more of the following. 1. Performs maintenance, repair, or construction of state highway infrastructures and associated rights-of-way in highway work zones. 2. Operates equipment on state highway infrastructures and associated rights-of-way in highway work zones. 3. Performs any related maintenance work as required on state highway infrastructures in highway work zones.
Your record is public. Most information in your license file is open to the public. Law enforcement agencies, insurance companies, and others check hundreds of thousands of drivers' records each year. Physical or mental condition of a driver are not public. Copies are available on request from DMV for a fee with a valid reason. Public records of minor traffic convictions and collisions are kept for 3 years. More serious convictions are kept up to 10 years. Some laws affect availability of the public record and how and by whom it may be accessed. Your private record is only available to the DMV, courts, and police.
Ladies and gentlemen, case study 2. Lucky Walter Crashalot is driving the new Dodge Dart he just won on game show Press Your Buck. Unfortunately for Walter, he was too involved with the smell of his new auto to notice the car in front of him. Walter Crashalot rear-ends the driver in front of him and causes severe damage to both cars. Now, they estimate that the total damages to both cars are at least $1,000. Looks like Lucky Walter wasn't so lucky after all. But what should he do now? Should he leave his car and walk home? Or should he stick around and exchange insurance information? What does he legally have to do?
Well, Walter must remain at the scene of the crash and exchange insurance information. If there is any property damage in excess of $1,000 or any injuries or fatalities, then he needs to report it to the DMV within 10 days. If there were any injuries or fatalities to the parties involved, no matter the amount of property damage, then they should be reported to the police or CHP within 24 hours.
Got it? Good. Now, good luck on the Section 2 quiz.